Under Florida law, the owner of real property bears responsibility to operate and maintain that property in a manner that is reasonably safe and properly marked or warned of hazards known to exist. Thus, the homeowner, as well as the business owner, has a responsibility to those who come onto the property or premises to maintain that property free from hazards and to warn those who enter the property of those hazards that are known or that do exist. Homeowner and business or premises liability insurance will typically provide for the payment of medical bills incurred by those people who enter legally onto the property and are injured. In addition, liability coverage is also usually provided, but the limits of either medical or liability coverage are dependent upon the type and amount of the coverage purchased by the owner. Violation of building codes or ordinances which contribute to the accident, in other words, the angle and width of access ramp or the height of a balcony or railing, can be essential in helping to establish liability. Any fault or liability on the part of the injured party becomes an issue. If each party shares in the blame, the recovery of damages by the injured party will be based upon the percentage of blame that the jury assigns to the other party. This is the concept of comparative negligence. So if the parties agree or a jury finds that the parties are equally at fault, the total amount of damages awarded as full compensation for the plaintiff's claim will be reduced by 50%. A person may be specifically invited onto the property, or the property may be such that there is an implied invitation to enter, such as in the operation of a store or a business. Also, the property may contain what is known in some jurisdictions as an attractive nuisance, such as a swimming pool or a playground. In that case, the owner should anticipate that uninvited guests might enter the property. In such cases, the law usually requires efforts to resist such entry, such as a fence around the pool. Compliance with such code provisions is required to avoid legal responsibility for injuries. Business owners can be held responsible for injuries suffered on their premises as the result of third-party acts, such as robbery, murder, or assault, when it can be shown that the owner was aware or should have been aware of the danger of such acts to patrons based upon past events or prior warning. Where it can be shown that the business owner knew or should have known that such an act could occur on his or her premises, and no effort was made to warn or to protect the patrons, such as lighting, signage, security, or security guards, then that business owner may have liability for the injury that occurs.
Carlson, Meissner, Hart, and Hazlett, serving the community since 1971.